Thank you to everyone who's filing into our webinar now. We're excited to have you here. My name is Lauren Altabelli. I'm the director of the Founding Civics Initiative at the Jack Miller Center. The Jack Miller Center is a Philadelphia-based nonprofit that works on civic education in both higher ed and with K-12 teachers. And with me today is Judge Douglas Ginsburg. Judge Ginsburg was appointed to the United States Court of Appeals for the District of Columbia Circuit in November 1986, and he served as Chief Judge from 2001 to 2008. He's a graduate of Cornell University and of the University of Chicago Law School. After law school, he clerked on the court where he now serves and for U.S. Supreme Court Justice Thurgood Marshall. And from 1975 to 1983, he was a professor at Harvard Law School. Prior to his joining the court, he was an assistant attorney general. Very excited to have you here, Judge Ginsburg, to talk about the Supreme Court sort of historically, but also the new term coming up, which is going to start on October 7th. Before we jump into the questions that I have for you, and later we'll get to some questions from the audience, I just wanted to run over some sort of logistics for our audience. I know many of you submitted questions ahead of time when you registered, and we have a few of those ready to ask. But if any questions occur to you throughout the webinar, please submit them in the Q&A box at the bottom of your screen. You should be able to submit questions to us. I have some JMC colleagues sort of in the back end monitoring the question and answer section, so we'll get to those towards the end. I also wanted to let you all know that we are recording this webinar. In a few days, we'll be able to get it up on YouTube, and we'll share the recording with all of you in case it's useful for you to return to. And lastly, we will have a feedback survey that we'll share with everyone who's here, just so we can get a sense for how useful you found the webinar, if you learned anything really interesting. It's helpful for us when we're thinking about future programming, just to get your feedback. So with that, I think we'll get started. And where I want to start with Judge Ginsburg is way back at the beginning in the Constitution. So the Supreme Court is outlined in Article 3, which when you look at the three articles that outline the three branches, Article 3 is definitely the shortest. So I'm wondering if you could just tell us a little bit about what functions the founders included in the Constitution for the Supreme Court, and maybe what was left out back in 1787, and maybe what's been filled in since then.
Sure, Lauren. Well, thanks for having me, and enjoying working with the Jack Miller Center, and looking forward to this hour that we have to talk about the court and then and now. Well, what you said could not be more true. There are 7 in this little pocket edition of the Constitution. There are 7 pages on Article 1 defining the powers and limitations of the Congress, and 2 pages on Article 2 dealing with the executive branch, the president, and everybody of the 2 million people who now work for the president. And Article 3 is just barely 1 page, just spills over a little bit more than 1 page. And of the 3 sections in Article 3, there's really only one that deals with the structure of the courts. And it's a couple of sentences, so I'm going to read it. The judicial power of the United States shall be vested in one Supreme Court, and in such inferior courts, that's me, as the Congress may from time to time ordain and establish. That's the first sentence. So the Constitution sets up the Supreme Court and leaves the rest of the Congress back in Article 1 to fill in the details. It does provide in the second sentence, these are all key, that the judges, both of the Supreme Court and the inferior courts, shall hold their offices during good behavior, which means lifetime, unless impeached by the Senate and convicted in the House, and have a compensation which shall not be diminished during their continuance in office. The way in which the British Crown and the royal governors controlled the judiciary was that they had they did not have tenure, and their compensation could be reduced. And then under the Articles of Confederation in our various states, there are judges appointed for 2 years in some states or a few years in other states. And a judge who doesn't have a long view and is looking at this next job is not the judge you want to be in front of.
Right. You want a judge that wants to be there for a long time and has a long view ahead of him.
And doesn't want to please his masters.
Right.
Right. So that Congress was very, Constitutional Continental Congress was very prescient and wise in limiting all of these restraints on judges. The second clause or section is about the judicial power, what it means, what cases the Supreme Court can hear, and it's basically cases that arise from a federal law or a treaty entered into by the United States. And then the third section is just devoted to defining treason. So that's all there is. And we now have a court system with about 25,000 employees, very modest. The federal system, bear in mind, the federal system, the Supreme Court, the dozen courts of appeals below that, the 90-some trial courts below them, that pyramid handles fewer than 5% of all the cases in the United States. Your state courts carry the burden of 95% of all the cases because they don't involve federal laws. They involve local crimes and zoning and divorce and child custody and all those things that make up the huge docket of the state courts. Whereas in the federal system, right now, in the last dozen years, we've had a huge influx of immigration cases. Always a relatively modest percentage are criminal cases because most crimes are at the state level. Same thing. So the federal system is very distinct from the state systems. If I'm talking to teachers, I can assure you that many of your students do not know there are two systems. Many of the adults that I meet do not know that. And it comes as a kind of a shock when they realize that here they are, fully mature citizens that have never really understood that. Well, your students, I know, will do better. So everything else was left to the Congress to fill in. And initially, they created a system of circuit trial courts and circuit courts. And the trial courts had a local federally appointed judge that would sit there locally, and one of the justices of the Supreme Court would come and sit together with that local judge and go from city to city doing this, town to town, I should say, as they then were. And that was called riding circuit. And Supreme Court judges had to ride circuit until well into the 19th century. So as the country grew, the Congress created more. Of course, there were more states, there were more districts, more courts of appeals, and it became impossible to keep adding a justice to the Supreme Court whenever there was a new circuit. And it became impossible for the justices really to ride around and sit with all the appellate courts. So there then was a period, from probably the 1820s until relatively, well, really even very recently, during which these courts grew up pretty much autonomously. That is, communication and transportation were not cheap the way we know them today. People didn't go lightly across half the country for a meeting, and they would rely upon the postal service for communication for the first 100 years. And so the folkways and traditions and even the local rules of the federal courts tend to vary. And even today, every district court of 90-some and every federal circuit court, a dozen, has its own rules, as well as a set of uniform rules that apply across to all of the courts. So when lawyers go into a federal court, they need to look up the local rules before they begin to represent someone. The Congress has from time to time created specialized courts. Right now, there's a Court of International Trade that sits in New York and just hears cases arising under the national or federal trade laws. And there is a court in Washington, a Court of Claims, which hears cases in which somebody is making a claim for money against the United States. It might be a federal contractor or a disappointed contractor who wanted to get the contract. It might be someone who was injured by a postal truck or what have you, and they have a claim against the United States. And there's an appellate court for that type of case, which hears only claims against the United States, tax cases, and patent cases. So it's a highly specialized court with three specialties, I grant you. Unlike any of the other federal courts. There have been courts that existed for a time when they were needed and were then abolished. The Temporary Emergency Court of Appeals was created during the Korean War to deal with cases arising under the wage and price controls that there existed then. And it lasted about more than 20 years before all those cases were liquidated. And then the court was just disestablished. So it's been a flexible system in that the sense that the Congress responds when there's a need to make a change, and has proven itself quite adept and well considered in doing that. It doesn't do it lightly, to say the least. So there are now almost 1,000, about 900 federal judges in the country. That's all. There are tens of thousands of state court judges, but fewer than 1,000 federal judges under Article 3 of the Constitution. Another thing that the Congress has done is create courts that are not Article 3 courts. The judges are not granted life tenure and safety against the reduction of their salary. Those are courts that handle matters, for instance, arising from the territories, not from the states, not from within the 50 states. There are Article 1 courts that deal with other specialized topics, courts that deal with Social Security matters in the first instance. Can be appealed. All these cases can be appealed finally to an Article 3 court, where a citizen has those protections of a judge who is, or judges who are independent of the government. So I don't think that exhausts the answer, but if there's more that you want to know, I'm happy to go on.
Yeah, well, it sounds like because Article 3 is so sparse, Congress has had to fill in courts and judges since 1787. And also you mentioned the Article 1 courts, which are even created by the executive, right? So both other branches are involved in sort of creating and extending the federal justice system beyond just the Supreme Court and the appeals courts.
Yes, well, I mean, as you're alluding to, in the federal courts, the president initiates the nomination of someone to be a judge,
right.
But it's the Senate that confirms or refuses to confirm that person for a life tenured position.
Right.
Quite right. Not even the number of justices on the Supreme Court is specified in the Constitution. And so that changed. It started out, I think, at 3 and then 4, was 6 for a while. At one point, it was 10, but it's been 9 since 1869. So it's sort of settled in as 9, and everyone's pretty used to that. It could change, of course. We can deal with that again later, if you like.
Yeah. Yeah. Well, so now that we've sort of set the groundwork with Article 3 and sort of the creation of the federal court system, I wanted to look more specifically at the Supreme Court. And I was wondering if you could talk a little bit about what it takes for a case to make it all the way to the Supreme Court. And also if you could talk a little bit about what the Supreme Court's workload is like.
Sure.
So how does the case get there? And then also what is the workload of the Supreme Court?
So under the second section of Article 3 that I mentioned, there are a small number of cases that originate in the Supreme Court. Cases involving ambassadors, lawsuits from one state against another state. They can't go into either state's court pretty clearly. And so those are actually in the so-called original jurisdiction of the Supreme Court. There are not many of them. And it's now, maybe it wasn't when there were 3 or 5 or 6 members of the Supreme Court, but it is now completely impractical for a court of 9 to try a case. And so when a case in the original jurisdiction arises, the court appoints a so-called special master to hold a hearing, take evidence, act just like a judge, make a recommended decision, and then the court makes its own decision based on that record. And the majority of these have been one state against another, because a lot of the state's boundaries in the East, in particular, have boundaries that were defined by royal charters, and the royal charters often said the midline of a particular river would form the boundary, and rivers shift. That's their nature, and so then you get into claims for one state against another over where the new boundary really is. So apart from those few original cases that originate in the Supreme Court, cases come from either the federal system or the state system. And if they arise in the federal system, they're parallel. The states have a three-part system. There are a couple of states still that have only two levels, trial court and a Supreme Court. But almost all the states have an intermediate appellate court, just as in the federal system. So whichever system it arises in, the losing party in a trial will appeal that judgment to the Court of Appeals, federal or state, as whatever system it's in. And the losing party on appeal may seek review in the state Supreme Court, or if it's in the federal system, in the U.S. Supreme Court. Now, in the U.S. Supreme Court, it used to be that there were a lot of cases that were within the mandatory jurisdiction of the court. That is to say, they were heard by appeal. The losing party had a right to appeal to and be heard by the Supreme Court. And as recently as the 1920s, when Chief Justice Taft complained about this, they were hearing 400 cases each year that they really shouldn't have been hearing, that were not terribly important cases, but there was a right to appeal. And Chief Justice Taft persuaded the Congress to create, to narrow the grounds of appeal. And so all the other cases, very few left by appeal, would be heard by requesting review by the Supreme Court, asking for a writ of certiorari, which would mean that asking the Supreme Court to tell the lower court to send them the record, certify the record, so that they can hear the case. And whether it's state or federal, those applications for review now number about 8,000 per year.
Wow.
And frankly, it's obvious that most of them are not cert-worthy, worth the court's time to resolve. And in fact, it's been hearing fewer than 80 cases, fewer than 1% of the requests over the last probably 15 years or so, or maybe certainly last decade. When I was clerking in the court for Justice Marshall in the 1970s, mid-70s, the court heard 160 odd cases each year. So that number is cut in half over a period of 50 years since I was there. No one can really say for sure what accounts for that. Justice Gorsuch has said taking 75 or more of the most difficult cases in the country every year is enough. Chief Justice Roberts has suggested that now that we have electronic research for everyone, you don't get cases where, you don't get nearly as many cases where two federal courts of appeals have interpreted the same statute in different ways. And that can be intolerable, to have people's rights under the federal law or the federal constitution differ from depending on where they live in the country. And so if it's a true conflict, the Supreme Court will almost always take and resolve those cases. Maybe not immediately, maybe to wait to see how a few other courts line up on them. But in general, that's a significant part of their caseload, where it's not appealed, it's not as of right, but the court really feels obligated to resolve those anyway. Coming from the state courts, it's eligible for review in the Supreme Court only if the case turned on a federal law, or is alleged to violate the federal Constitution. And so that's the latter category is typically what happens. Some state law is challenged by the person subject to it. They lose in their state Supreme Court and they seek review, having argued all along. They have to have started from the beginning with this, claiming that the law violates the federal Constitution. They may also claim it violates the state Constitution, which has a lot of similar provisions, due process and equal protection and so on. So if people fail to make that argument from the very beginning, they've lost it, it's forfeited. But if they do preserve it, then they have a chance to ask the Supreme Court for review.
Right. I was going to ask, when you mentioned the decline, you said when you were clerking, it was about 160 cases. Now it's about 80. I was wondering if it maybe had to do with the complexity of the cases, and if because there are so many more federal laws now, I would imagine maybe that contributes to it. But you said that really, it kind of just depends on what the court thinks is really important, and they can determine which ones they want to hear each term, right?
Yes, I mean, as I say, they feel obliged to resolve some where there's a conflict between two circuits, but otherwise, yes. And some things come to the fore, I mean, for a period of time. So during the Warren Court era, the court was reviewing criminal procedure cases and holding more and more rules violated or practices violated the due process requirements for criminal procedure. That went on for a long time. In recent years, the court's had a spate of cases involving the internet. It's had a group of cases in the last few years involving the powers of administrative agencies, and those things are both likely to continue in the future because the internet's not going anywhere, and neither are the agencies.
Right. Yeah. So before we get too current, because I do want to get to the 2024 term, I want to review a few historical landmark cases that have really changed how the court, what the court's role is. So first, I was wondering if you could talk a little bit about Marbury v. Madison from 1803 and how that decision changed sort of how the court works and how it influences what happens with its decisions.
Sure. Well, that case was written by Chief Justice John Marshall, often referred to as the Great Chief Justice, who served from 1802 or 3 to 1831. He wrote almost all of the court's decisions. There were just a handful of dissents or even separate decisions over the whole period of his tenure there. And he was a staunch Federalist, appointed by President Adams, I believe it was, who consistently interpreted the Constitution to favor a strong federal government. And of course, the whole Constitution was the result of compromises between those who wanted to keep power in the states and cede as little as possible to the federal government. So whenever there was an ambiguity, he seemed to resolve it in favor of federal power. So in this particular case, though, it involved a very peculiar situation. One of the judges appointed by President Adams had not yet received his commission, and so could not take office. When President Jefferson came in, his Secretary of State, who was Madison, refused to deliver the commission to the man who had been given this office as a local magistrate, a local judge, and he sued for it. And so the question went to the Supreme Court very quickly. In those days, the Supreme Court sat only briefly. They heard only a few cases each year. They met in a tavern before they didn't have even a hole in the Senate basement to sit in, which came later. And so the decision was, although in Mr. Marbury's case, he was not entitled to his commission. In the course of it, the court said that it had the authority to decide whether a law was constitutional or not. And this is called judicial review. The court reviewing the law and comparing it to the Constitution and asking, is it consistent with the Constitution? There were very few instances of this under, well, only one that we know of for sure under English law, but in the colonial period and the first 11 years under the Articles of Confederation, judicial review was not uncommon. And so the court has said, look, this is the essence of having a written constitution. You can look at it and look at the law and compare them and determine whether the law is within the powers that have been granted by the people to the Congress. And in this particular instance, he managed to avoid actually holding anything unconstitutional. So there wasn't anybody to really complain about that. But it set the stage. It was a very well-reasoned opinion, I think, and it set the groundwork for the authority of the court to say that a law, state or federal, is not consistent with the Constitution and therefore invalid and unenforceable. There were not very many cases calling for judicial review in the 19th century. And there were even fewer based on the Bill of Rights, the first 10 amendments to the Constitution. So judicial review really didn't flower until into the 21st century, particularly during and after the First World War. And during the First World War, the federal government took measures that were challenged sometimes successfully because they, for instance, censored the mail, arrested people criminally, convicted people for criminal sedition for opposing the draft, a bunch of things that that percolated up to the Supreme Court after the war was over and were held unconstitutional. And that really set the pattern so that now it is not that unusual for a court to say that something is unconstitutional. And indeed, most of the questions before the Supreme Court ask, is this practice or this law unconstitutional?
Right. I think that's the most commonly asked question nowadays. It seems like whenever a case is in the news, it's really about constitutionality. I want to jump forward in history a little bit. That's okay with you. Maybe 150 years after Marbury v. Madison, there's this big case called Brown v. Board of Education, which we know, I mean, I'm sure everyone here is familiar with the case. I think it's a required case to be taught in many states in U.S. history and government classes. But I was wondering if you could explain a little bit about the role that case and that decision had in protecting and expanding civil rights for groups previously denied those rights by the law. So if you could just talk a little bit about.
Sure, I'm particularly pleased with the question, Lauren, because having clerked for Justice Thurgood Marshall, this was the culmination of his 20 years of campaigning for equal protection with respect to abolishing segregation. But in order to understand the case, we have to go back from 1954 when it was first decided to 1896. Because that's when the case of Plessy versus Ferguson was decided. And that was a case in which Homer Plessy, African-American man who could pass for white but didn't, was arrested in Louisiana because he refused to give up his seat in a segregated rail car that was reserved for white passengers. And the case was a setup. Mr. Plessy and the constable who arrested him and everybody involved, and I think the judge too, wanted to test this law because they thought it was unconstitutional. What kind of equal protection of the laws is it if people can be put down or segregated by race? And as opposed to being protected under equal protection of the 14th Amendment, which had passed in 1868 or 9. So the National Association for the Advancement of Colored People, NAACP, Legal Defense and Education Fund, devised a strategy to attack separate but equal, which had metastasized and infected everything in the Jim Crow South and some things in the North. And they began by challenging segregated public law schools. Justice Marshall himself had been unable to attend the University of Maryland Law School, where he lived in Maryland, because it wouldn't accept African Americans. And so the very first case that he brought when he was out of law school was against the University of Maryland on behalf of a Black student, and he won. And this went on with law schools for years because the law schools would devise, believe it or not, all sorts of ways of evading a requirement that they not segregate or otherwise discriminate against their students. And so they would say, okay, well, we'll have a separate room for you, or a different teacher will teach the course, or we'll pay for you to go to the neighboring state or to a private school. So they started with the law schools because they thought the judges would understand this. And in fact, that's what happened. Eventually, the Supreme Court decided 4 or 5 cases involving state law schools. Then they went to the colleges, and then Brown versus Board arises from K-12 schools. And the core question was whether separate educational facilities were unequal, inherently unequal. even if they looked the same, and they never did. They never did. The schools for the blacks were much inferior. The teachers were not necessarily, but the facilities always were. Well, it was inherently unequal and therefore unconstitutional. And the court held that that was indeed the case. And I'll quote what they said. The court said that segregated education, quote, generates a feeling of inferiority that may affect students' hearts and minds in a way unlikely ever to be undone. And the court concluded that the doctrine of separate but equal has no place in public schools because separate educational facilities are, as the plaintiffs claimed, inherently unequal. Now, the court was groundbreaking. I mean, this had been permitted separate but equal under the fantasy that it was really equal since the 1890s. And it had very little immediate effect because the school systems did not want to desegregate. Like the law schools, they used evasive techniques. They would say, sue me. Until somebody sues me, I'm not going to change my local school system. In a case that came up as late as 1968, the county had said, well, we're going to give the parents a choice. We're not going to discriminate. Parents can choose what school they want to go to or send their children to. Well, that had no effect on the segregation of the schools as they correctly anticipated. And the court then said that segregation was to be driven out root and branch. And that's when the local federal courts started with busing. They'd already done a little bit of that, really trying to facilitate true integration of the schools. It took a long time. And while if you look at residential patterns, schools are still overwhelmingly one race or another, maybe not 100%. A lot of schools are not, but there are some, particularly in suburban areas, that are. But they're not legally segregated. If they are one race, it's because that's where they happen to be located. Legal segregation in schools is gone. And this set the standard for every other aspect of public life. And the Congress started legislating in 1964 with the Civil Rights Act for desegregating public facilities of all kinds, theaters, and restaurants and hotels, and so on. It took a long time.
Right. Yeah. So now that we've taken sort of a historical look at the court, I know you're very excited to talk about the upcoming term. So the Supreme Court returns on October 7th, which is next Monday, I believe. This coming Monday is the 30th. The following Monday after that is when the justices will be back at the court. So can you give us a little preview into some of the cases that they're going to hear, and maybe if there's any sort of common themes or topics that seem to be reoccurring, could you talk about that a little bit?
Well, every so often the court gets a case that involves students, particularly, like Tinker against Des Moines, Iowa, where the students were protesting the Vietnam War by wearing a black armband, totally non-disruptive, symbolic speech. And the Supreme Court said that the school system could not discipline them for that was protected speech. Well, in the upcoming year, we've got things that are, I would say, more aimed at not necessarily students, but adolescents. And there's a big group overlap there, obviously.
Yeah.
So one case that's coming up that's been granted is the United States versus Shkrmetti, hard to say, Skrmetti, which involves a Tennessee law prohibiting transgender-related medical treatments for minors. So the law says that 3 types of medical interventions are forbidden for minors, and they are puberty blockers, cross-sex hormones, and sex transition surgeries. And it's an equal protection clause. It's also due process, but basically an equal protection challenge. And the United States took up the case on behalf of the minors who wanted to have these procedures. And it's arguing that this law makes a classification based on sex, which would put it under a cloud, to say the least, because quoting the United States, a teenager whose sex assigned at birth is male can be prescribed testosterone to conform to his birth gender, his male gender identity, but a teenager assigned female at birth cannot. cannot be treated with testosterone, that means. The state comes back and they say, look, this regulates sex transition treatments for all minors, regardless of sex. And quoting them, no minor may receive puberty blockers or hormones or surgery in order to transition from one sex to another. And so they're saying it treats all people alike without regard to sex. And the central issue in the case, as in so many equal protection cases, is what's the standard of judicial review? If it's a law that is ordinary run-of-the-mill law in which states regulate some activity, often economic activity, the question is there a rational basis for the law? If there's any rational basis, even if the state, when the legislature passed it, didn't give that reason, if the lawyers for the state or the judges themselves can think of any rational reason for having a law, then it's not a denial of equal protection, because the courts are out of the business of regulating economic activity. But if it involves a suspect classification, like race or gender, then some heightened standard of review is required. Is the law narrowly tailored to fit the purported purpose? Is the purpose one within the clear power of the police power of the state? And if it involves a fundamental right, usually free speech, then it's strict scrutiny. And almost no law passes strict scrutiny. I mean, there have been literally a few, over the years, and they've all involved First Amendment matters, and they're almost all, and they are therefore very hard to sustain. Anything that seems to tranche on free speech, to censor it, is under strict scrutiny and very hard to justify. So 3 levels of scrutiny. None of this is to be found in the text of the Constitution. It's evolved over the period of the last 60 or 70 years, perhaps. Oh, more than that, last 80 years, to sort out how the court will approach these different types of problems. And it's very common. In fact, another issue that's before the court this term is the Free Speech Coalition versus Paxton. And there the question is whether a law imposing age verification requirement for access to online pornography, whether that passes First Amendment scrutiny. So state, I guess it's a state, I'm not positive, it could be a locality, has passed a law saying that a internet provider cannot allow someone to access pornographic websites unless they verify that they're above certain, whatever the minimum age is. And we have right now very widespread lax enforcement of age verification requirements. You just ask the person on the other end of the computer, at the computer screen, are you older than 13 or what have you? And they say yes. But there's no verification beyond that. And to require something more beyond that raises this question then, well, is that an impediment to free speech in the form of a person wanting to consume content? Someone else is offering the content. It happens to be pornographic content. And so, again, the main question is, well, is there a rational basis for do we want just a rational basis, or is this subject to some heightened scrutiny because the First Amendment is, it's in the neighborhood, if not directly involved. And this sort of a case now following a trend of the court grappling with how the First Amendment applies to the internet. Last term, they had a case called Net Choice, in which Texas and Florida had each imposed so-called content moderation requirements on platforms operating, available in their states. And basically, they were saying you have to balance to some degree your speech on political issues, just like the old fairness doctrine in broadcasting. You had to give more or less equal treatment to both sides of a controversial issue. And of course, here it was concerned with political issues. And the court said, you can't do that. You cannot fragment the internet into different free speech or different speech zones in every state or any state. And so those laws were unconstitutional as imposing on the free speech rights of the platforms and of the people whose messages they post. So this is, I just heard an argument 2 weeks ago in the TikTok case where we spent 2 hours on what's the proper standard of review. Once we get past that, then we can decide whether the law passes it or not. And then there's another one that's kind of interesting, and maybe some of your teachers, students can relate to this. A case called Garland against Vanderstock. That's going to be heard next month. So in October. And this involves so-called ghost guns, which are firearms. Well, I don't want to beg the question. They are guns that a person can buy online from a kit. You just buy the kit and then assemble the gun. So it has no serial number. It cannot be traced to a manufacturer. And that is an impediment for law enforcement, as you can imagine. And so the question is whether a regulation that interprets the word firearm in the National Gun Control Act to include gun kits, whether that exceeds the authority of the agency to define or to apply the law respecting firearms. Is a gun kit a firearm? And last term, I guess it was, the question was, what is a bump stock a firearm? The Bureau of Alcohol, Tobacco, and Firearms in the Treasury had issued a regulation saying bump stocks were firearms and were subject to all of the regulations that apply to firearms. And the court said it just doesn't fit the definition of a firearm. You can attach it to a firearm, but it is not itself a firearm, and it couldn't be regulated under existing law. The Congress, of course, can pass a law within the limits of the Second Amendment to try to regulate bump stocks, but the court was just applying the same term they're going to be applying in the ghost gun case.
Yeah. We do have a few questions from the audience. Was there maybe one more case you want to highlight for the upcoming term, or can we turn to some?
I'll just say briefly that there's one other, well, actually, this was last term, but another gun case, Rahimi. And the question was whether a person who was under a court order to prevent domestic violence, maybe has to stay away from his spouse, can nonetheless acquire or possess a firearm. And the court said a regulation or state law prohibiting that was lawful. So it's one of the few regulations of firearms that has survived Second Amendment scrutiny. So I'd be interested to know what we can do something on administrative law if you want to take the time, or we can find out what the teachers want to talk about.
I think we have some good questions from the teachers, and then maybe if we have some more time at the end, we can talk about administrative law. How's that sound?
Sure.
So we did have a question from someone who's here with us. She said, everyone's familiar with the impact of Marbury v. Madison regarding judicial review. What are some other cases that you think should be studied for their impact that do not receive as much attention?
Oh, well, as much attention in the curriculum, I guess.
Yeah, or sort of generally. I mean, Marbury v. Madison is such a famous case. Are there other cases that come to your mind that have had great impact that maybe are just not as well known?
Well, of course, Brown versus Board we covered, and it's very well known as well. The press does a pretty good job of publicizing the cases that are really important. They don't necessarily portray them very well, but they do bring them to public attention. There's a case called Purcell that comes up just a few years ago. And there, the court said that in a pre-election period, such as we are in right now, courts should not change the rules applicable to the upcoming election. And so when there's an ambiguity in a statute involving the election, stay with whatever the interpretation has been. Or if the administration of the state has been interpreting it one way, just let that go through the election and then afterwards take up the question. Because it's too confusing to the public, it's disruptive for the state trying to administer the election, and it can really result in some some difficulties. And what's happened in the last few years, that was very significant. But in the last few years, nonetheless, states 4 years ago, several states changed their laws very close to the election time, after Labor Day. And they've created questions that the courts pretty much had to answer and would try to answer in such a way as to not disturb things. But when there's a new law, what are they going to do? They've got to say either it can be enforced or it cannot be, if it's a constitutional attack on it. And so in Pennsylvania, for instance, the court itself decided that ballots could be counted, even though they were postmarked, I believe it was, after the election date. It was supposed to be okay if they were delivered after the election date, but they extended that, and it was partly because of, well, I think entirely because of COVID. But the court was changing the rule, maybe for what seemed like a valid reason, but changing the rule as the matter was going forward. Right. So there was a little bit of chaos introduced into a number of states. And that hasn't happened yet, as far as I know, in the current electoral season. But I would be very surprised if we don't see last minute, or at least late in the game, changes starting now, and difficult decisions facing courts as to how do we keep from disturbing things so that bollocks us up the election.
Right. Well, that's interesting. I hadn't heard of that case. I mean, I'm not an expert on the Supreme Court, but seems like an important one that probably comes up every 4 years, right? I mean, nobody thinks about election rules until you're trying to run an election, and then suddenly there are all these questions.
Yeah, but it's been much more recent in recent years. Yeah.
Okay. Yeah. Another question from our audience, which I think is pretty interesting, is, has there ever been a serious consideration for requiring the Supreme Court to rule unanimously on decisions?
Oh, interesting. No. In fact, there's no majority. The decision of the Supreme Court is embodied in a judgment. And the judgment issues if 5 justices wanted to issue. Right? It's a different piece of paper. It's different from the opinion that they've written. And it's the judgment that has the force of law. Of course, someone receiving that judgment tries to abide by the rationale for it in the decision. But there are, unfortunately, so the rule is 5, but there are unfortunately cases in which there is no majority that agree on any one thing. And so you might get 3 different opinions, no one of which has 5 justices. And the task of the lower courts and of the lawyers who have to advise clients on this and maybe litigate on it is to put together whatever overlap there is to see, well, what do 5 or more actually agree on, if anything. That's very unfortunate, but it does happen with some regularity. That's to say, probably at least once every term. There's another problem in which, if a judge is recused in the Supreme Court, you have a court of 8 instead of 9. And there's no replacement. If I recuse myself because of a good reason that I might seem to a reasonable person look like I'm biased, maybe because I have stock in a company, there's another judge who can come in and replace me. That's not a problem. Only the Supreme Court justices in the federal system are not replaceable. And there was one case, Alcoa aluminum case in the 1940s, where there were not enough justices who were not recused to create a quorum. And so the case was heard by the Second Circuit in New York, and it was final. There was no possible way of the Supreme Court reviewing that case.
Wow.
So those are very unfortunate situations, and judges are encouraged not to own stocks, or at least not to get themselves recused on a regular basis. You can own a mutual fund or something so you don't particular about a particular company. But nonetheless, some people do, I do, but not very many. And sometimes you've inherited it, or it's in a trust that you can't really change. But anyway, with the Supreme Court justices, they can't be replaced, and it's very unfortunate when there are 8. Which means that their standard for recusing themselves has to be a little more forgiving than it is for the Court of Appeals and for the district. Yeah. They have to have really a good reason, a sort of irrefutable reason to get off the case. And there are always controversies about whether a justice should have. Justice Kagan, for instance, was involved in the in the Obama administration's drafting of the healthcare law, Obamacare law. But she felt she did not need to recuse herself when the constitutionality of that law was challenged. Maybe because the parts she worked on were different, but some people complained and asked her to recuse herself, and it's up to her to make that judgment. And we just assume that we all make these judgments in good faith.
Right.
And I assume she did too.
Right. So the question about requiring unanimity, you had said only 5 justices need to agree in order to issue a judgment. And I know the saying goes sort of that more often than not, the Supreme Court is either unanimous or almost unanimous on most decisions. And the ones that make the headlines are the ones that are like a 5-4 split or a 6-3 split. So do you think requiring unanimity would affect that many cases? I mean, I think it would, right? Not every case comes down as an 8-1 or a 9-0, right?
No, it'd be completely impractical.
Right.
About 40% of the cases are unanimous, and that figure has been approximately correct for decades. About 40%. So they may need to resolve a split between 2 different circuits, but it seems to them clear that one circuit was right and one was wrong, and they all agree on that.
Yeah.
It's only these high-profile cases where they tend to be more fractured and get more publicity because they are profile cases.
Right. We had one more question I wanted to ask it was submitted ahead of time by someone who registered for the webinar. And this is sort of just an opinion question. I don't know if there's a real answer, but how likely is it that the number of Supreme Court justices will be expanded in the future? Do you have any insight into these kinds of conversations that are happening now about maybe expanding the court to 11 or 13 or perhaps even bigger than that?
Well, it was tried in 1937. President Franklin Roosevelt was very unhappy with the decisions of the Supreme Court, holding unconstitutional some of the novel measures that he was getting the Congress to pass to deal with the Depression. The court changed its view in 1938, 37, pardon me, but earlier in 1937, the president had proposed to add a law to add a justice to the court for every current justice who was over the age of 70, of which there were 6. So that would have created a court of 15. And that was so blatantly an assault on the court for the substance of its decisions, for disagreement with what it was doing, that it got no traction. There were 96 members of the Senate. There were more than 60 Democrats, the president's party. It got 20 votes. President Obama named a commission to make recommendations for reforms relevant to the courts and the Supreme Court in particular. And they made a series of recommendations. They did not recommend expanding the court, although that was one of the things that they took up and considered at his request. It was almost foreordained that they would not, because probably close to half of the members of the commission had themselves clerked on the Supreme Court and knew how it functioned, and thinking that it functions quite well, and that making this departure because you disagree with the output of the court would just be an invitation for the next group that disagrees to expand it further and further, and it would lose its character as a court, and it would certainly lose its standing as a nonpartisan, non-political body.
Yeah, thank you for your input on that. We're almost towards the end here. So I want to say a couple words about the Jack Miller Center, and then I want to give it over to Judge Ginsburg to talk a little bit about civics fundamentals. Again, thank you all for being here. I know it's a busy time of school year for you all. So I just want to encourage you that if you enjoyed this webinar, or if you're interested in more webinars like this, to sign up for the Jack Miller Center newsletter. We're going to drop a link in the chat in a moment where you can sign up. And also just sort of stay in touch with the Founding Civics Initiative, which is the work that the Jack Miller Center does with teachers. We're going to drop a link in the chat too to the Founding Civics homepage on our website. So if you want to check that out, you'll be able to hear more about, or you'll be able to read more about what we're doing. And then if you sign up for our newsletter, you'll get us to your inbox. It's just once a month, so we won't like totally spam you all the time, but there's great updates about events that we're running and resources that you can use. And then Judge Ginsburg, I know you want to say something about civics fundamentals before I show a quick video.
Yeah, so Civics Fundamentals, there it is, available at civicsfundamentals.org. is a set of 100 videos that I made, each one addressing a question on the naturalization exam. 18 states have now in some way expressed their desire to require passing the naturalization exam for graduation from a public high school. Some actually require it, some are in the process of doing so, some are considering it. This is one of the materials available for doing that. And it's gamified. Kids actually love it. Set up for vocabulary and so on for grades 6 through 12, but adults actually like it too. So, Lauren, can I run one example? It's only a minute and a half.
Is it the one we talked about?
Yeah.
Yeah. So I have it pulled up on my screen. I might just share it if that's all right with you.
Please do.
All right.
Equality between states. What is an amendment?
The Constitution is changed by amendment. The framers gave us the Constitution in order to form a more perfect union, and they gave us the leeway to amend the Constitution in order to make it still more perfect as the times change. But it isn't easy, and it isn't to be done lightly. An amendment must be approved by 2/3 of the House of Representatives and 2/3 of the Senate, and by 3/4 of the states. Critics claim it's too hard to amend the Constitution, but it is designed to be hard because a government should be stable. But there are times when making a change is absolutely critical. After the Civil War, for example, the 13th Amendment abolished slavery. The 14th and 15th Amendments extended the equal protection of the laws to all citizens and protected the right to vote. In 1920, the 19th Amendment gave women the right to vote, the greatest expansion of liberty in our history. These amendments and others gave us a more perfect union, just as the framers intended.
What is an amendment? Correct answers include a change to the Constitution, an addition to the Constitution,
Thank you, Lauren. So the question and the correct answers are prescribed by the Naturalization Service. This is completely nonpartisan, and it's effective. It's free for teachers who want to use it. We send them, if they want them, vocabulary lists, flashcards, lesson plans. I mean, and it's so flexible because it's all on the internet. I mean, you can ask a student to look at one tonight and discuss it tomorrow. You can run it in class. They never take more than 2.5 minutes. And even on the most mundane questions, you can learn something. So one of the questions is, where is the Statue of Liberty? Well, in 2.5 minutes, we can talk about immigration and naturalization and what the history was at Ellis Island and turn it into a history lesson. So there's something in there of interest, no matter what the question.
Yeah, I mean, I've watched a number of the videos, and it's great that they're so short, and there's always some interesting sort of like factoid or tidbit that you didn't know before that you can get out of the video. And it's great to use in class, or like you said, as a homework, because they're so brief. So I want to thank you, Judge Ginsburg, for being here with us for the past hour. And I want to thank all the teachers who logged on to the webinar. We will follow up, like I said at the beginning, with a feedback survey. It'll only be a few questions. If you could take a minute when you receive that email to fill it out, we would appreciate it. And we look forward to maybe doing this again, Judge Ginsburg, and we'll share the recording of this webinar as well in case it's useful for anybody to use later. But thank you all, and we appreciate it, and I hope we'll see you soon.